So I wanted to go through a few things that I see constantly with people like Yusef and Brandon Williams, and I think that's his name, Brandon. But they're constantly referring to a code section and making the claim that everything is commercial, that all crimes are commercial, and that everything, when you go into the courtroom, everything in there is all admiralty and maritime law. And I wanted to kind of go through where all this stuff comes from and point out that it is all 100% incorrect. So right now we are taking a look at 27 CFR 7211, and this is commercial crimes, and this is the code section that they constantly point to prove that all crimes are commercial. And what it says is commercial crimes: any of the following types of crimes, federal or state: offenses against the revenue laws, burglary, counterfeiting, forgery, kidnapping, larceny, robbery, illegal sale or possession of deadly weapons, prostitution, including soliciting, procuring, pandering, white slaving, keeping house of ill fame, and like offenses, extortion, swindling. You get the point. It's pretty much everything. And so they point to this and they say, okay, well, this is proof that the federal government has instituted all crimes as being criminal. But the thing that they leave out of this, and I'm going to jump over here and we're going to go to, we'll just say USC codes. And I'm just going to grab one of these links here. And if you look down here, that was, and we'll flip back over. So if you look right here, this is 27 CFR 7211. Now, the one thing to note is this is a CFR, not USC, which means this actually isn't a legal code. This is, the CFRs are more for like explaining what the legal codes are actually saying. They're like the deeper explanation of what is trying to be portrayed in the USC stuff. So it's not actually something you could go into court and start bringing this up, because these are not actually legal codes to bring up. But in nonetheless, we're going to jump over here and take a look at 27. It's Title 27. Title 27 says intoxicating liquids or liquors. I'm sorry, and intoxicating lizards. But the point is this code section is where that came from. And if you go in here, we've got general provisions. Let me see if I can find. There's a definition section in here, but actually this doesn't list it. So you would have to go to the CFR to get more details. So the point is that Title 27 is not relevant to what we're actually interested in. It's unless you're dealing with intoxicating liquors. So if we come back over here, again, this is a CFR, not a USC code. It's just here for an explanation. But the other flip side of this is that they have converted everything over to commercial crimes, and then the courts that you're walking into are not actually legitimate constitutional courts. They're actually maritime courts. And that's the other thing that everybody like Yusef and everybody else that's trying to sell goods, because one thing you'll have to note on all of these guys is they're all selling something. So, but they try to push this off and make that claim. Now, where are they getting the other claim? Well, it's from this court case, this Propeller Genesee Chief. This is a 1851 case. So let's jump in and take a look at what it says. So this is the first quote. It says, "Nor can the jurisdiction of the courts of the United States." So just a little bit of background. There were two ships that crashed on a lake, and the court is trying to figure out whether it has jurisdiction. Actually, the court said it did have jurisdiction, but they were trying to get the case dismissed, saying that it didn't. And so this is what the judge had to say: "Nor can the jurisdiction of the courts of the United States be made to depend on regulations of commerce. They are entirely distinct things, having no necessary connection with one another, and are conferred in the Constitution by separate and distinct grants. Now, what is he talking about? He's talking about the difference between maritime jurisdiction, which is what the court and the suit was originally filed in, and the claim that this is something to deal with commerce. Now, what the judge is saying is that maritime courts and commerce are two distinct things. They cannot be combined. And there's quotes that are provided that aren't actually in the court case, but it goes on and it says, these quotes, I wish I'd have kept the quote from people, but they go in and they say things like, under commerce, cars and people driving cars in commerce and everything would be covered under maritime, and nobody would be guaranteed a jury trial. But that quote doesn't actually show up in that court case. So we're going to take a look at what actually does. So we've already got the judge admitting that there is a distinction between maritime jurisdiction and commerce. And so we're going, and it is, if you go look at the Constitution, it actually has two separate sections on these two things. But it says, he went on to say, the law, however, contains no regulations of commerce. Now, what law is he talking about? He's talking about the act that they enacted to add the power to regulate these maritime incidences on lakes and navigable waters, not just in the ocean. Because originally the thought was that the Constitution only covered the oceans, and this is the court case that kind of said no, any kind of water that you're navigating across to do commerce between states or between nations is covered under this statement, because the Constitution doesn't specifically say that it's only limited to the ocean. And so he's saying the law, however, contains no regulations of commerce, nor any provisions in relation to shipping and navigation on the lakes. It merely confers a new jurisdiction on the district courts, and this is its only object and purpose. It is entitled an act extending the jurisdiction of the district courts to certain cases upon the lakes and navigable waters connecting the same, and the enacting clause conforms to the title. So the act that he's talking about, that's all it did, is it added jurisdiction to the courts for these navigable waters whenever they're dealing in commerce. So in other words, if I have a lake and me and my buddy bump into each other out here on the lake, that we're not doing commerce. This is not something that would be involved in maritime. There's no contracts. There's nothing like that we would be dealing with. And so this act only covered those types of activities, but it was not hinged on commerce. In fact, the act itself doesn't even mention the word commerce. And so he goes on to say, it is evident, therefore, from the title, as well as the body of the law that Congress is passing, or is in passing it, did not intend to exercise their power to regulate commerce, nor to derive their authority from that article of the Constitution. And if the constitutionality of this law is supported as a regulation of commerce, we shall impute to the legislature the exercise of a power which it has not claimed under that clause of the Constitution, and which we have no reason to suppose it deemed itself authorized to exercise. So in other words, that act that we're talking about, giving the court jurisdiction over these navigable waters, had nothing to do with commerce, and they're openly stating that as we go through here. Indeed, it would be inconsistent with the plain and ordinary meaning of words to call a law defining the jurisdiction of certain courts of the United States a regulation of commerce. So he's going on to expand on this. It doesn't even, he's saying it doesn't even make any sense to say that this act that we're talking about had anything to do with regulating commerce. So, and to be clear, a maritime court is there for usually where you have international vessels that are going past each other, and say there's an accident. Well, you need to have some type of a court system, because you can't bring a Japanese ship and the people on the Japanese ship and try them under American law, because that would make no sense. So they have these maritime courts that deal only in contracts. So they literally just look at the contract, look whose products were on it, who owns the ship, and all that kind of stuff, and who was at fault, and they settle it through contracts, or they settle it through this international court, if you will. So a maritime court is more like an international court, not an American court. And so this act just expanded it to deal with these lakes. And so it goes on to say, nor can the jurisdiction of the courts of the United States be made to depend on regulations of commerce. So they can't base the jurisdiction of a court on commerce. They are entirely distinct things, having no necessary connection with one another, and are conferred in the Constitution by separate and distinct grants. The extent of the judicial power is carefully defined and limited, and Congress cannot enlarge it to suit even the wants of commerce, nor for the more convenient execution of its commercial regulations. And the limits fixed by the Constitution to the judicial authority of the courts of the United States would form an insurmountable or insuperable objection to this law if its validity depended on commercial power. So he's literally saying the opposite of what the sovereign citizens and Yusef and everybody else that tries to say that we're running in maritime courts or admiralty courts. They really are making this stuff up. They're referencing a code section for crimes that has nothing to do with the majority of the code, and the court cases that they rely on have nothing to do with commerce.